All right, so the language is clear. I want to welcome my guest this hour, criminal defense attorney Melaney LaGrone. Melaney, I want to thank you so much for joining me this evening. Truly appreciate it.
Thanks for having me.
All right, let's start off by taking a look at some of these phone calls. First and foremost, the prosecution conceded all the phone calls made between Greg McMichael and his wife. Now, the defense had cited spousal privilege, but there is some question as to whether that survives this expectation of privacy or lack of expectation of privacy when you are incarcerated. Were you surprised by that move by the prosecution?
Actually not. I would expect them to say spousal privilege for that reason, because they know that that's a way that they're going to be able to not, not get those calls in. It's a right, spousal privilege is what it is, and I do think it is separate from the actual argument that they're making regarding being able to allow the jail calls in, because that is more of a privilege other than, a right to not have those in.
Yeah, I mean, that was a really strong argument by the prosecution, the fact that this is not a right. The fact that they're even allowed to make phone calls is a privilege, and privileges do not get the same scrutiny as a right, for instance. Now, a couple of arguments made by the defense were interesting, and even the judge said, these are novel issues for the court, and they talked about the fact that it's a violation of due process. And the essence of that argument revolved around the fact that the purposes, or the stated purpose, of recording phone calls is for protection, to make sure that there aren't any plots or anything going on to try to come in and get somebody out of jail, and safety and security. But then the second part is also that there's no criminal activity being conducted. Now, if you look at those reasons, it doesn't apply when you're talking about someone making a phone call and then turning around and using their words against them. By the same token, the warnings that are on when you make the call say exactly that what you say can and will be used against you. So it is a novel issue they're trying to raise here.
Definitely. And I think that the warning that you get in the beginning is what sets it apart. It's basically already telling you that anything that you say on this call can be used against you in court, and that this phone is recorded. And even the manual that was that they were reviewing in there, I didn't even realize that they actually had that written out. But it tells everything spelled out on how these phone calls could be used against you. So basically, if you're going to get on the phone and start talking, then you should be prepared to hear these again in court used against you.
Yeah, at the end of the day, right, when you talk about these constitutional protections, it's about the expectation of privacy, which is why we have a spousal privilege. There's an expectation that when I speak to my wife or someone speaks to their husband, that those are private conversations entitled to privacy. But when you talk to someone over a line that they tell you is recorded, and they tell you that what you say can and will be used against you in a court of law, if it comes to that, then the expectation of privacy is gone.
Exactly. It's no longer there. Not to mention, when you're on the phone in a jail, you're not alone and by yourself either. So anybody could overhear your conversation as well. So there is no privacy there. Absolutely not.
Yeah, I mean, not only the people sitting next to you, not only the guards behind you, but also the people listening in or the people recording it. They've already told you what's going on. All right, so we'll see. Have to see how the judge comes down on some of those rulings. Right now, we're going to take a break. Melaney, please stand by. For 2 days now, attorneys have argued about whether Ahmaud Arbery's mental health records should be part of the case against his accused killers. But would it essentially be putting the victim on trial as well? We'll talk about that next, coming up here on Court TV.
The court is absolutely correct. The question here is, why would this diagnosis be relevant to any issue in this case? So that leads us back to what are the issues in this case? And the issues in this case are citizen's arrest and self-defense. Therefore, Mr. Ahmaud Arbery's mental health is not relevant on any issue at all in dispute in this case because it sheds absolutely no light on any issue in this case. 401 is absolutely correct. I mean, it has to, any tendency to make the existence of any fact that is of consequence. How is his mental health? He could have been a Rhodes Scholar. He could have been plucking his arms like a chicken running down the street. His mental health is absolutely irrelevant to the reasonableness of their actions. And I agree with the court. I believe that we should go and assess the relevancy of this prior to going into the actual quality and quantity of these medical records.
Welcome back to Court TV Live. I'm Michael Ayala. Now, you just heard prosecuting attorney Linda Dunikowski's stance on the admittance of Ahmaud Arbery's mental health history as evidence. Now, we have heard the state multiple times over the past 2 days say that Arbery's mental health history has zero relevance in this case. They have contended over and over that Arbery is a victim of the defendant's actions and not vice versa. And this case is about the reasonableness of the defendant's actions, not Ahmaud Arbery's actions. So should a victim's mental health history be used against him in a case involving possible self-defense? That is the focus of today's close-up. Now let's hear some of the argument made by the defense in favor of admitting Arbery's mental health history.
The state is citing cases to you under the umbrella of relevance to say, well, there's a lot of cases where you can attack the credibility of the witness. We're not talking about that. We are so far moved past that issue. You're hearing it now from me. It's not about the credibility of Ahmaud Arbery. And it is okay to recognize and celebrate who Ahmaud Arbery was in 2012 when he graduated high school, but it is reckless to disregard the mental health illness that plagued him for 8 years leading up to this moment in February 23rd, 2020.
All right, now let's listen to exactly what the defense wants admitted as far as his mental health is concerned.
It will be records from the Department of Corrections that we have. That is the Department of Community Service, I apologize.
Department of Community Supervision.
Department of Community Supervision, the probation department that supervised Mr. Arbery in the 4-year relationship and the notes and thoughts and comments of the probation officer, as well as the statements being made by family to probation back and forth. So those are documents, yes. There will also be a 911 recorded call that the state agrees has been authenticated, but in terms of its relevance and all that, I understand the state wants to be heard on that. But we'll have a 911 call as well. We have all of the video evidence of Mr. Arbery in the community behaving in ways and interacting in ways that we feel, in addition to 404B relevance, it's relevant because it is thought and expression and behavior that we believe, our expert would say, is consistent with this diagnosis. So you'll have that.
Now, in opposition, the state argued that all that health information, mental health information about Arbery was a raggedy patchwork. Let's listen to Linda Dunikowski argue the motion.
The expert's conclusions lacked sufficient probative value and thus were inadmissible under 403. Obviously, we are not there yet, but my concern is that Mr. Sheffield just told the court that one of the things he wanted was to put his doctor up in order to have you listen to her as part of the ongoing sealed sort of package. The state would object to her at this point testifying, given we're bifurcating this issue. So the court, though, however, the state wishes the court to be aware that 403 analysis is an appropriate analysis to conduct, because in this case, the court said, because of the rather raggedy patchwork of sources that the person had to deal with, I will direct the court to the raggedy patchwork of sources. These sources are Mr. Arbery's worst days of his life. Absolutely the worst days of his life when he is involved in law enforcement. This is not every day of his life. And to have their doctor come in and go, well, I looked at all this stuff and it supports a conclusion based on a 2-hour form that got filled out as a diagnosis, the state contends that's a raggedy patchwork of sources that their doctor had to work with, because their doctor never ever met Mr. Arbery and never talked to him on his best day.
I really love Linda Konikowski's style, the words she uses. Very interesting. It's going to be a great trial. Let's bring back criminal defense attorney Melaney LaGrone. Now, Melaney, this is a thorny issue. It's a difficult issue. I'd love to get your initial thoughts on whether these mental health issues and problems should be in a case like this.
Michael, not at all. I mean, this is, to me, outrageous if it's even being considered, because just for public policy reasons, can you imagine that no one who has mental health issues would want to go seek help, that they wouldn't want to be able to speak freely with their doctor and, get help for their issues, because someone could use this against them one day in court as a victim? So we're not talking about them being the defendant on trial or something like that, and their mental health issues are being used, in that way. He's a victim in this case. So his mental health issues have absolutely nothing to do with this case whatsoever. And there's going to be a whole bunch of can of worms being opened if that's allowed, because for public policy reasons, it would not be right at all.
Yeah, and all those things you mentioned are what make it a very thorny issue. It has very serious public policy implications. But let me tell you this, Melaney. The judge went home and did a little research. They made some of these arguments yesterday. He came back today with a case called Vermont versus Bolaski. And I went in and I read some of the decision, and this was an appeal from a self-defense case where the person was trying to bring in some of the mental health issues of the victim, claiming that the person was crazy and had some mental health issues, was on different medications. And the judge in that case said that issue, the issue of the mental health of the victim, was in fact relevant under 404 and 405 to the fact that if you're going to judge the reasonableness of someone's actions, which is what a self-defense requires the jury to do regarding the defendants, then you have to judge the reasonableness of their reaction to the defendant. So the defendant's state of mind in terms of their motive intent, which is, and we know, allowed under 404, 405, then it becomes admissible under those purposes. The case in Vermont said that. Now, we know it's not controlling in Georgia, but I thought it was interesting. And really, if the judge is looking at that case as instructive, that's a real win for the defense.
That is very interesting. When they mentioned that case, it makes you think. But even in this particular case, the self-defense argument is, at best shady. So I still don't believe that it should come in at all.
Yeah, I want to play a quick soundbite, Melaney, from Lee Merritt. He's, of course, the attorney for the Arbery family. He feels similar to you. Let's take a listen.
There's another thing to consider, whether if it even has a narrow relevance to it, whether the prejudicial impact, the impact that it has on a jury will outweigh its probative value. And that's something that is always at issue. I imagine if they try to introduce any piece of this evidence at trial, that objection under 403 will come up. And again, ultimately, even if it were to be let in, yes, there's a concern about the prejudicial impact on the jury, but it doesn't change the facts of what these men did.
I think that kind of goes to what you said, Melaney. The other part of that Bolaski decision was that once you get past the 404, 405, there's still the 403, whether the probative value outweighs the prejudicial effect. So there's still that consideration as well.
Absolutely, absolutely. And it would definitely be more prejudicial. So it's going to be an interesting, it's an interesting argument already, but it'll be interesting to hear how the judge rules on this.
Yeah, it's going to be very interesting to see how he sort of parses through not only that, but the privacy issues that are concerned as well. So we'll certainly, again, keep an eye on that. Melaney, stand by. It is time for us to take another break. Now, there are several new developments in the cases against the other officers involved in George Floyd's death. Now, their trial date has been moved, and one defense attorney wants decades of police use of force files, and another alleges that someone from the prosecution team leaked information to the media. We're following all that breaking news coming up next, right here on Court TV.